taken a short break to give the participants and the judges time to go for lunch, and they'll be resuming in about 45 minutes for the afternoon session, whereby the NASA petition continues, and the representing Raila Odinga and Kalonzo Musyoka will continue their presentation. Now, this afternoon, constitutional lawyer Mutaha Kang'u is expected to take to the podium. They have about an hour left in their presentation. They had about 5 hours to present their case that began this morning by senior advocate James Orengo, who basically set the stage for this petition, talking about the inconsistencies that have been realized in this petition and the substance of their petition, which included the forms that were used to declare this election, if they were in the prescribed form or not. He also spoke briefly about the law and the fact that the law wasn't complied with in this election, basically setting stage for the other presenters. He also spoke about the inconsistencies that involved quite a number of polling stations, and the fact that even the forms that were used by the IBC to declare this election were not in the prescribed forms, noting that others were not even stamped as per the rules set by the IBC itself, and also alluding to the fact that the rules indicated that if the ballot papers were not stamped, then they did not count, and yet some of the papers that were used were not stamped, and yet they were used to declare the election. Earlier on, the Supreme Court gave the NASA their request, so Raila Odinga and Kalonzo Musyoka, the request to access the information in the service, and that was limited to read only, however, with leave to copy. So they were allowed to copy those results, and the Supreme Court also allowed the parties to the petition to access the service and appointed two IT specialists with the supervision of the Registrar of the Supreme Court, of the Judiciary rather, plus another person that could be or should be appointed by the Judiciary, by the Registrar of the Judiciary, to help in that process. And also there was indication that the parties will appoint the agents who will be included in that process. All those reports are expected tomorrow by 5:30 p.m. To be filed right here in the court. And that also meant that the applicants and the respondents will have an opportunity at the end of the submissions that should end by tomorrow to present on the findings from the servers, from the 34 A's that they were requesting that should be audited. The court indicated that the forms 34 A's will also be scrutinized, and the IBC should avail these copies to the parties and certify them also. So that was earlier in the morning, essentially giving the NASA or the petitioners an opportunity to scrutinize the servers, although they were given those, they were given what they asked for, albeit with a little bit of, caution, and obviously there were also the calls for not allowing the parties that are going to look into these systems access to security features like the firewalls that are being used, the softwares that are being used, and the rest. So that permission was granted. That began with James Orengo, as I have mentioned. Now, one interesting thing from the presentation by James Orengo is coming up with the formula that was used to award the Uhuru Kenyatta more votes against Raila Odinga. Now, this was presented by Otiende Amolo, who is also the MP-elect for Rarieda constituency, and that formula has been shared widely. That is y is equals to 1.2045x plus 183,546. If you look at the face of it, it doesn't make a lot of sense, but that is the formula that they are saying was used to award more votes to Uhuru Kenyatta and deny Raila Odinga votes. Now, this was presented by Otiende Amolo. The other thing that was canvassed by Otiende Amolo is the results that were displayed were unverified, yet they were used to declare the results. And they said that these results, as declared, were not based on the Form 34As as required by the law. And they also spoke extensively, Otiende Amolo also spoke extensively about the rejected votes and says there are 5 versions of the rejected votes that don't add up. Now, these are some of the things that were canvassed in this petition that we will definitely be discussing with my panel a little bit later on. But on this day also, there are quite a number of stories also making your headlines. But let's begin right here at the Supreme Court. Now, the Supreme Court has allowed NASA's application to have access to IEBC's servers and the ICT system, albeit under restrictions and supervision of the Registrar of the Supreme Court. Now, all the parties will be allowed to have 2 experts during the process of looking at the servers. And the court has also ordered for all the forms that were used to declare the presidential election to be presented. Andrew Cheng with more.
Yes, Mr. Orengo.
The ruling of the Supreme Court is a far departure from what happened in 2013, as it has shown a spirit to move away from the technicalities. The Supreme Court has ordered IEBC to open its systems for scrutiny. Among what should be provided is the specific GPRS locations of each of the KIMS kits used in the elections. The court has also ordered for a list of all the KIMS kits, the polling stations they were assigned to, and a list of all the kits that were not used in the elections. The court then ordered IEBC to provide details of all those who logged into its systems.
Login trail of users and equipments into the IEBC servers. N. Login trails of users and equipments into the KIMS database management systems. O. Administrative access log into the IEBC public portal between 5th August 2017 to date.
NASA has also been granted the request to have IEBC be compelled to provide all the forms that were used to declare Uhuru Kenyatta the winner of the August 8th elections.
Certified copies of the original forms 34A, 34B, 34C, prepared at and obtained from the polling stations by presiding officers and used to generate the final tally of the presidential election, and pursuant to that production, leave is granted for the use of an aid or reading device to assist in distinguishing any fake forms from the genuine ones.
The access into the IEBC systems, however, will not be unfettered, as it will be supervised by the court. NASA will also only be able to read and or copy the information they require.
An ICT officer designated by this court from among its ICT staff and 2 independent IT experts appointed by the court shall supervise access to the technology in paragraph 72 above, as such a venue as they may determine in consultation with the parties. The parties to the petition are entitled to have a maximum of 2 agents or experts in each of the above exercises. The agents shall at all times comply with the directions of the registrar and the ICT officer to ensure expeditious conclusion of the above exercise.
The reports from the 2 audits of the forms and the ICT systems are expected in court tomorrow at 5 p.m. Each of the parties is also allowed to compile a report and present it to court after the audit.
Of the system.
Andrew Ochieng, NTV.
Says the national strike is still on despite the union's faction led by the chairman John Bale asking nurses to go back to work as they wait for word from the government. Now the union acting chairman Joseph Ngwasi now wants the nurses not to relent as the union negotiates with the government and the county government. Ngwasi says it's only the Secretary General of the union who has the powers to call off the strike once the stalemate has been resolved.
While John B. states in the media that the nurses CBA was a hoax,
the Council of Governors have maintained that the CBA, whose cost is more than Kenya shillings 40 billion, is unaffordable, which begs the question of who is misusing John B in an attempt to divert the CBA talks. John B, once a national chairman of KNUN, is no longer the chairman of this union after he was removed from office in February 2017 and June 2017 due to various accusations of constitutional immorality. The move by His Excellency President Uhuru Kenyatta of signifying the intention of ensuring nurses' issues are unaddressed is welcome, and we are waiting for an official invitation for talks that we hope will end this stalemate. I also wish to state that nurses' strike is still on, and it shall only be called off by the General Secretary.
All right, let's take you now to the county of Kiambu, where the government plans to hire nurses on temporary basis to alleviate the suffering of patients owing to the ongoing nurses' strike. Now, the Kiambu Level 4 Hospital Governor, Ferdinand Waititu, expressed his concerns, calling the situation dire. Waititu said he will convene a meeting with all the Kiambu leaders to discuss and offer solutions to the residents who cannot afford treatment in private hospitals. He assures the residents that the service will resume soon, while urging the striking nurses to return to work stations to their workstations as they negotiate with the government, and that negotiation continues.
Suffering because of this strike, and we thought that the nurses could be considerate, because as it is now, the central government is not stable. Our county, the newly elected county government is also not stable. There is nobody to negotiate with them, and we had requested them that they can resume their work. Meanwhile, we are settling, then we negotiate with them once we are settled. And this is a case of about 2 or 3 months. And even the president told them the same. So, sisi tutachukua hatua.
Now, more than 7,000 cassava farmers in Kilifi County are set to benefit from a European Union-funded initiative that will see them increase their yields. The funds, worth 700 million shillings, will run for a period of 5 years and is designed to ensure that the 7,000 farmers in Kilifi can better their farming methods. The project targets potential farmers who own several acres of land to enable smooth takeoff after they are trained. The fund will also ensure that cassava farmers access quality seedlings that will guarantee a good crop.
Zile mbegu bora ambazo tulezi recommend ama zinakuwa recommended.
Kutoka hapa tutaenda kwa zile sub counties. Tutakuwa na kitu inaitwa selection criteria ambayo tutaweza kuchuja ni kina nani watahusika katika huu mradi na sehemu ambayo itakuwa ya kueleweka, so that tuwe na ile viable ama commercial production ya
All right, from a lecturer to a governor, Dr. Joyce Laboso has had to quit the professional journey a day after she made history, becoming the first woman governor of the county of Bomet. She sat down with Victoria Rubadiri to recount the journey thus far and share her grand plans in her home county of Bomet.
Madam Governor, how does it feel to make history, not just once, but now a second time, of course, in the county of Bomet?
Wow, quite, I think I've not yet quite got used to it. You know, it's, well, it's a pleasant surprise, and I'm happy that, you know, these people of Bomet have given me this honor to be their governor. So I'm still getting used to it. I'm not quite used to it yet, but we've started. We want to start work right away and get on with the business that they wanted me to get on with.
You had a rather unceremonious entry into politics. Did you ever see it turn out this way?
Initially, I didn't think I was going very far in politics, but as I said, once I'd gotten in, I realized I could do this thing. And you know, and every time I keep surprising myself, you know, even more. When I started on the governor one, it was also like, yeah, why not? I've been in this thing for 10 years. Yeah. Why don't I try something else? I also have that itch. Every 10 years, I somehow have to try something different.
And politics is not easy. You got a lot of opposition just off of the fact that you were a woman. Some also castigated you for marrying someone who was not within your community and told you to vie in another county, for instance. Just getting past a lot of that opposition and a lot of that rhetoric, what did you do?
I think for me, and I would really advise a lot of people, you know, there's a lot of propaganda and a lot of, you know, trying to bring you down in politics. And I think you must counter that, but with facts, so that, and diffuse the focus on marriage, for example, diffuse the focus on my being a woman, and talk more and go a notch higher and keep talking about the failures of the person who is on the seat vis-a-vis my manifesto and what I'm standing for. I realized, wow, this seat really meant so much for so many people, and particularly women. The number of women leaders across the country that came to witness my swearing in really told me a lot. And really, I want to tell you that it has put even an extra burden on me to perform, because really, if these people are so excited, all these women across Kenya, and who came personally, with Isiolo, I don't know, you know, Turkana, wherever, you know, Central Province, were all literally here, and all of them to say, you know, thank you, you've done it for us. We have now broken the glass ceiling. You have helped us. We can also now, you know, move in as women and get the courage to do what you have done.
And speaking of which, what are your plans? You had a 7-point manifesto.
Yes.
For the county of Bomet.
Yeah, I want to really see if I can change the lives of women, really. So water is going to be key. You know, across this county, everybody was saying, you know, save us from this perpetual going to the river and, you know, and going for long distances, and there's no water, and, you know, just so water is going to be key. Also, you know, use the different ways of trying to see how to improve the economic, you know, ability of each of the families. Yes, it's an agricultural area. We've had a very serious problem with maize growing, you know, for about 4 or 5 years. We've not really had any good crop on. So it's what to do that can be able to change their lives using what they have, the potential that we have in this. So it is tea, it's doing things around tea that can improve what remains with the farmer.
Your late sister, Lorna, is not with us anymore, but what do you think she would have said if she saw you today?
Actually, the Bible that I used to be sworn in, I used her Bible, the Bible that she had used, because all along I came into politics really through her. First of all, by working with her when she was a politician herself. So all along, people have always said, you've always been in the shadow of your sister. I think I have come a long way. I've come out of her shadow. I have been able to make something of myself, and I think she would really have been proud to see that her sister, whom for years she thought was just an academician who was really looking to be professor and other things, has gone and even probably done better than she would have done if she was she had been alive. So I know she would have been proud, and so would my mother, who is really the backbone of why we are all in politics. She was like the first woman, counselor, and she was doing all manner of things that many women would not have thought.
So is Madam President in sight at any point?
And why not? Let's do this governorship and do it properly, and I'm sure Kenyans can see how I've performed, and maybe, you never know. I always say my destiny is in the hands of God. He is the Almighty, and He decides. And if after 10 years, yes, why not? It's always in the radar somewhere, but we leave it all to God.
Great.
Yes.
Thank you so much, Madam Governor.
All right, and in about 25 minutes, the judges will be back right here in court, and it will be the turn of Mutaha Kang'u to present, and this is also the legal issues that are involved in this case, and Mutaha Kang'u probably would be the last person because they have an hour, unless they will divide it, but he's probably the last, because I'm just looking at the hour. He's been requested not to consume the whole hour, so I think he's the last, but Duncan Okach now joins me. I'm still waiting for the other lawyers to join me, but let's begin the conversation with Duncan. We have seen the way the petitioners have divided their presentation in this case. We began with James Orengo. He established the case, and then we went to Otiende Amolo, who also did his job, and then they've divided it. About 5 lawyers have presented in this petition, but they have majored mostly, if you look at the last 3 lawyers, they have majored mostly in matters of law. What do they seek to achieve with this?
Ken, yesterday when we were speaking, we actually said that based on the previous request that they be given time to start today, they actually promised that they will be more organized and it will actually take less time compared to if they had started yesterday. If you look at how they have organized themselves, and you've aptly put it into context, each particular lawyer is actually handling a particular role, and which roles, when connected together, symbiotically assist and aid the entire petition. So that once James Orengo has laid the legal foundations of it, we go to the crux of it, which has been laid down very well by Senior Counsel Otiende Amolo. He has actually gone into the depths and the nitty-gritties of their petition. You have also seen Lawyer Paul Mwangi now going into the legal aspects in terms of other peripheral legal issues, which will still be central in the final determination by this particular court.
I'm interested in that, Duncan, because of mostly what they spoke about in terms of the involvement of public officers in this campaign. This is one of the issues that I didn't really think they'll bring it in, but they brought it, and they took so many minutes just to talk about the involvement, and they talked about the election process, the election being a process rather than an event. And I think that is the reason why they brought the participation of public officers in this.
Ken, for the viewers who were watching us yesterday, we actually brought this into perspective. Yesterday we said that this case is won on the basis of the threshold of the law. And we indicated that the law, and especially our constitution, in Article 81 and 86, which the LSK will also come in and put its weight in terms of its interpretation of those particular articles, you notice that there is a qualitative part of it and the quantitative part of it. The qualitative part of it are the qualities surrounding the free and fairness of an election. But we have the quantitative aspect, which now go to the aspect of each ballot and actually the totals of those ballots. So each of these components are enough when flowed to actually lead to a nullification of an election. And that is why NASA has actually gone all out to actually produce evidence on all the limbs. So when they bring in the aspect of public officers interfering or trying to influence or shepherd the thinking of the party of the voters, it is a very major issue when you look at the qualitative aspect of that election, which is not an aspect that takes place on the polling day. It is actually an aspect that takes place way before polling day. And that is why when you look at the pronouncements and they've actually gone straight, Senior Counsel Kongo Mogeni has actually gone straight and specifically laid that out, which aspects even include the president himself.
Yes.
And they are not very light issues, and it is important for the court to now give direction in terms of what it perceives and whether it offends the qualitative aspect of an election.
All right, and just to speak about the few public officers, are they state officers or public officers? They're state officers, but they're public officers, right?
Yes, because
they're CSs, right? Yes. So on CS Musheru, he's quoted to have said that we are exempted, we can campaign for the president. That is what Musheru is quoted to have said. Kiunjuri is said to have intimidated voters. President Uhuru Kenyatta, He's said to have told chiefs that tutatafuta nyinyi after the election, and all this, and also he spoke about CS Eugene Wamalwa also, who campaigned. And if you look at the totality of this presentation, is to discredit the whole process from the campaigns right to the voting and tallying, right?
Basically, that is it, because they have actually opened it up so that we are not only looking at what happened on polling day and the allegations on polling day. They've also stretched it out, and maybe it is because of the tenets of a free democracy and having free and fair elections, such that you don't only focus on the polling day aspect, because everything around the campaign period also affects the final polling decision by any Kenyan. So that when you look at those pronouncements and you gauge them based on the law, you'll find that there are several shortcomings which have been placed. And it is for them to try and show that these shortcomings, according to them, are enough to invalidate or to an election based on the influence that this particular pronouncement made. So that is a decision that the court may make, and it is important for the court to make that decision, because you notice previously there were issues, and people have been saying that it is important for courts to give us the line between public officers campaigning, public officers demonstrating what they've done, and we also have a law on as far as that is concerned. So going forward, the pronouncement on this will actually help Kenyans as we go into the subsequent elections to know the limits, if there are limits, if there are no limits.
All right, and then my question will be, in determining an election petition, what counts? Is it the process, or is it facts that can lead to a nullification because of irregularities? What determines it? What is the strict threshold for this?
And I've already indicated previously that we have several thresholds which must be looked at. And I said the first one is the qualitative and quantitative analysis. Then the next one is you look at how normally election petitions are gauged, so that whatever you allege, which now goes to any allegation you make, you must demonstrate it on a scale higher than a balance of probability, but lower than a strict beyond doubt threshold. So that once you make any allegation, like the ones they have made, they must demonstrate that that is it. But over and above that, you come to the threshold which is given by Section 32, Section 83 of the Elections Act, which is very clear, and it's something that has been submitted at length by the councils who have submitted, which is something that the court also dealt with in 2013, which they think that the court did not actually deal with it to their satisfaction. That's why they are saying that the court dealt with it by incurium, and they want this court to relook into it, and that is a major issue, and I said it yesterday, whereby the Section 83 was imported from the wordings from the equivalent section in Britain. And in Britain, they have used the word "and" to mean that you must demonstrate that there were irregularities, there were flaws in that particular process, and the election was substantially not conducted in accordance to the laws. But on this other side, it says that you must also demonstrate that these irregularities and these flaws and the non-compliance has actually affected the results you could have had. But fast forward to what we have today, which is now before our Supreme Court. They're actually faced with our law, which has actually substituted the word and used the word "or." If you look at "or," that is a disjunctive application of that particular section, so that you can actually demonstrate either. But that is my interpretation. Other people have their interpretation. It is the court to decide whether you must demonstrate both aspects. And we have proceedings in court. Both the High Court and the Court of Appeal have been faced with this question. And Ken, you'll find that even the courts themselves have given divergent views, divergent application, and it is still confusing. And even as we go to the advent of dealing with the other petitions which have been filed, it is important for the Supreme Court to render itself once and for all. And remember, I said it yesterday, they are not bound by their own decision or by the 2013 decision. Neither is the Court of Appeal bound by its own decision. They can actually depart from that.
All right, let me bring in George. George, we have seen quite a number of presentations from the petitioner, and right from the top, from James Orengo and Otende Amolo, they looked more of the technical bit. But since Okongo Mugeni took over, it's more of the legal aspect, and I bet that's where Mutaha Kangwe is going this afternoon also. Because what we had in mind when they were conversing this, when they were talking about this, is they were going to go technical, but they have really shifted to the legal matters more than anything else.
Ordinarily, in the sequence of presentation before court, you must first analyze layer bases of what your case is all about. And that's what James Orengo did. He laid a basis, the sum total of the historical aspect of the case. Then he brought out some part of the basis of the case, more so laying generally what the narrative will be. When we came to Otende Omolo, what he managed to do is go into the factual issues as it pertains to evidential value, the probative value, and analyzing the consistencies, inconsistencies, the gaps, especially on the facts themselves. The narrative was therefore to punch holes into the system itself on factual basis. This then means that the evidence had to be highlighted in one way or another. And sequentially, therefore, he was able to bring out the anomalies in the electoral process factually. This, what it has done is then related the narrative as is in the pleadings vis-a-vis the submissions. And having done that, that was complemented partly by the narrative by Okongo Mogeni, but more importantly also the narrative of law began to be packaged by Okongo Mogeni. What Paul Mwangi has managed to do is therefore purely go on a tangent in matters of law, and he is then gone first to look at what is ordinarily a crux of submissions on law, something called the burden of proof. Whether the burden of proof is as a civil matter or a criminal matter. Burden of proof is what you need to prove the court. There's an element of standard that you need to reach for you to reach out and discharge the elements that the evidence and the threshold that you need to meet. Now, burden of proof ordinarily in civil cases is where by the circumstances prevailing and the evidence before court, if there's a pointer towards the prayer that you've made, then you're going to be granted. And then in criminal cases, there must be no doubt whatsoever. For instance, if somebody has killed and charged of murder, there must be no doubt whatsoever that you committed it. If there's doubt, then that burden of proof is lower than that beyond any reasonable doubt, and therefore leaves a mark or a gray area, and therefore is lowered, and therefore, which means therefore you cannot be convicted. Now, the issues that will emerge here is this, for instance, is a constitutional matter a civil matter?
Okay.
If it is a civil matter, then is the burden that of a civil matter? If it is not a civil matter, then is the burden that of beyond any shadow of doubt, or is it higher than that, or in between? That's why you heard Paul Mwangi talk of the intermediary burden, in between. And in between is what? Is it an emerging practice of law? Or what has been set out to be in between, but the two burdens. The other issue that has been looked at in depth by Paul Mwangi is what then comprises a good election, as is required by the Constitution and law. And he talked and classified all of them into certain thematic areas. He talked of an election being accurate, an election being fair, being verifiable, secure, accountable, transparent. And he went out to analyze what this ought to be, and in relation to the issue, the facts and law, what in our context it ought to be. More importantly, what he raised is a very important issue, that the Constitution prescribes that anything under the sun, under its jurisdiction, which is inconsistent, it's null and void.
Okay.
If that be so, then it means even the election, if it is done outside the scope of the Constitution, therefore, it is inconsistent because that's the prescription of the Constitution. Although he attempted to depart the holding of the court previously as against the current situation, and said the holding of the court seemed to create a situation where you need to prove both qualitative and quantitative aspect of an election. Qualitative meaning that the processes must have been followed in the manner that he has explained them. Quantitative, you must then tally the votes so that then, although there could be the inconsistencies on one hand, they must have vitiated or removed the votes and clothe them away such that then the person who has been declared as the winner cannot be a winner anymore because the votes have been proved to be invalid through and through. So the scope being that you need to say vote 1, remove vote 1, vote 2, vote 3, 300, 400, until you come to a threshold either below 50 plus 1 or in the alternative completely unverifiable, meaning that you can't even say who the winner is. Probably moving to, a good example would probably the ECK, the last ECK election under Kivuitu. It became so unverifiable such that then we got into what we did in 2007 and 2008. But the point therefore is, should the court therefore stick to its older jurisprudence on the dual approach, which then he said there's qualitative and quantitative, or stick to one, where if the constitution, if an election is departing from the constitutional provisions and therefore is not within the sacrosanct of the constitution, that then becomes a violation of the constitution, is therefore null and void.
All right, we'll come back to talk about that. They're supposed to come back at around 3:30, but they might be a little late, so we'll take a short break. When we come back, I see arguments even on forums that are held by very elite people talking about if you think you're safe as an elected leader in this country right now, this case might just change that. It's not about presidential anymore. It's about questioning the whole system of the election. I'd like to touch briefly about that when we come back from break. Stay with us. We're still right here at the Supreme Court. Stay with us. All right, welcome back to the Supreme Court of Kenya. This is Raila Odinga and Kalonzo Musyoka versus the Independent Electoral and Boundaries Commission, the IEBC Chair Wafula Chebukati, and the President-elect Uhuru Kenyatta. Right there is the Supreme Court of Kenya, and of course they have settled in. I see the judges are in, so we will take you right inside the Supreme Court, where Mutaha Kangu takes over the presentations for about an hour. When they finish, we'll tell you what next. But for now, let's take you straight to the Supreme Court.
Yes, thank you, my Lord. I would like to start my submissions by clarifying one point that my learned friend Paul Mwangi made, and that is the point about the need to understand the context of the country you may be borrowing a legislation from and jurisprudence from. And that point is made at paragraph 15 of our submissions, where I have made reference to a quotation from my book, Constitutional Law of Kenya on Devolution, in which I refer to a number of decisions by this court, saying that context is very important. And we are saying that when this court in 2013 made the decision in Raila Odinga, I think a bit of understanding the context of the legislation we borrowed from in Britain was missed out. And that's the point we need to note, that the legislation we borrowed from in Britain is the legislation that uses the term or. And if we put that into account, we will get it right. But having said that, I need to go to the Constitution and start by drawing the attention of the court to our submissions at page 10, where we have a table that sets out what the legislation was in the National Assembly and Presidential Elections Act, Section 28, where the Constitution was not referred to. And Section 83, as it is today, which makes reference to the principles in the Constitution. And then that brings me to the question of the new dimensions in the electoral law and the interpretation of Section 83 that must be drawn from the new Constitution. That the new Constitution has put in place a number of principles to govern elections, and that therefore you cannot continue to interpret Section 83 without paying very serious attention to the new constitutional dispensation, to the changed constitutional framework. And so the Constitution becomes very fundamental, it becomes a new dimension, and it is our submission that that new dimension requires that an election must first be valid constitutionally before you even start raising the questions of Section 83 and how you interpret it. You first must measure that election against the Constitution as the supreme law. And once you are satisfied that the election was conducted in terms of the Constitution, then you can deal with other matters under Section 83. If you find that the election is not valid constitutionally, you don't even have to move to Section 83. You simply declare it null and void and do the necessary, take the necessary steps to move forward. And on that issue, a number of courts, I think, a number of scholars have made comments that say we ought to have considered the Constitution seriously. And we have in the bundle of authorities an article by Justice Professor Otieno-Dek, who makes reference to this issue at page 35 of his article. And I'll be inviting the court to look at that. Then, my Lord, in the book in which your article that was referred to yesterday was published as a chapter, we have another article there by Hyde Evelyn and Waikwa Wanyoike, and they also make that point at pages 79 to 80. And I think that point would be helpful to my lords. Now, this new dimension then requires that this court must fall back to Article 259 and ask itself, how then do we interpret the electoral law in the context of Article 81 and Article 86? And 259 talks about a purposive approach to interpretation aimed at giving effect to the purposes of the Constitution, the purposes that we had in mind when we enacted these provisions. We must take them into account. We must discover them. What is it that we wanted to solve when we put these provisions in the Constitution? And on that note, I will invite my lords to again look at my book at page 49 to 50, where I discuss the role of historical dimension to context. When you are interpreting the Constitution, you must look to the history to see what was the problem. And in Kenya, we have a serious history in terms of elections. And I'll take you back to the article by Waigwa and another at pages 86 to 90, where they go into very serious discussion of the history of this country as regards elections that led us to put these provisions in the Constitution. That history begins with the days of Jomo Kenyatta, when opposition parties, some were persuaded to join the ruling party KANU, that was KADU. KPU was formed. It was later banned, and its officials persecuted. When Kenyatta died, Moi took over, and interference with the elections continued, culminating into the 1988 Mlolongo elections. From there, we started fighting for reforms, and we went through, and up to the time when we started constitutional review, the law that provided for the Constitutional Commission specifically said that one of the issues we must consider and provide for are electoral reforms. And that history of stealing elections, interfering with elections, continued up to 2007, and you know the cost to peace that we suffered. And so we ended up with these provisions clearly in making sure that we must have credible elections. We must conduct them in a manner that people can see they are well managed, But, my lords, you can see that the evidence that has been adduced here, our efforts to have an electoral commission that can be trusted with this work seem not to be being realized. And perhaps because we don't have sanctions. People get away with this, and they have no incentives to do proper elections. And so we'll be emphasizing that we need to do something about the interpretation so that we can make sure that we don't continue with the mistakes of the past. And we must therefore ask ourselves, if we retain the interpretation that was taken in 2013, there are two things that may happen. On the one hand, you may want to say Section 83 is unconstitutional by trying to subject the Constitution to legislation. And in a system of a Supreme Constitution, you subject legislation to the Constitution. You don't subject the Constitution to legislation. And that will be, it will come to what Mwangi said, we will be trying to amend the Constitution through the back door. The other way would be to say, let us say Section 83 is okay, but the court must interpret it in a manner that is constitutional. The manner in which it was interpreted in 2013 can be said to have been unconstitutional because that interpretation then subjects the Constitution to legislation. And we will be arguing that, therefore, the easier route for this court is to revise its own decision and interpret that section that in a purposive manner that gives effect to what was intended to protect the electoral process. Now, when revisiting that section, my lords, there is one point I would like to emphasize, and that point is the use of the mandatory terminologies in Article 81 and Article 86. If you look at Article 81, the provision says that the electoral system shall comply with the following principles. The phrase is shall comply. And this court has interpreted that as being mandatory. And if you look at Article 86, it says at every election, the Independent and Boundaries Commission shall ensure. Again, the phrase is shall ensure, mandatory. And so the question I want to raise, which you must address, is does the use of those mandatory terms have some effect on the burden of proof and how it moves? Now, my submission is that the use of the mandatory term therefore means that all that the petitioner is supposed to do is to establish a prima facie case. And once he has done that, the burden shifts to the IBC to prove that they conducted elections that comply with the Constitution. That is the burden, the effect on the burden that I would like this court to note. The second thing to note there is the fact that those terminologies impose obligations on the IBC which ought to be observed. And it's incumbent upon this court to enforce those obligations if they think the IBC is not observing its obligations. And on that, again, I will refer the court to the article by Waiko and another at pages 97, at page 97 and also at page 93. Now, therefore, when you are seeking to revise that decision and you are interpreting the Constitution in terms of Article 259, you must bear in mind that 259 requires this court to interpret the Constitution in a manner that develops the law, in a manner that permits the development of the law and contributes to good governance. And so the question you have to ask yourself is, in terms of developing the law, does the jurisprudence that was developed in 2013 truly develop our law? Or should we as a court say, look, we have a responsibility to develop the law. We made a mistake here. Let us use our powers that are conferred under the law to revise this interpretation and develop the law in a better manner. And I want to argue that if you look at Article 2 in terms of the interpretation of this court being unconstitutional, if you look at Article 2 of the Constitution, sub-Article 4, my lords, you will see that it says any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency, and any act or omission in contravention of this Constitution is invalid. I want to submit that any law in terms of Article 2, sub-Article 4, includes the common law developed by the courts. So that if you find that your own interpretation that develops the common law is unconstitutional, then in terms of Article 2, you will be able to say, look, but at least here we have powers to correct our oversight. So decisions developed by the court, they form common law. It is part of the any law that ought to be consistent with the Constitution, just the same way even customary law ought to be consistent with the Constitution. Now, the last important point I want to make, my lords, is the point regarding the importance of elections in our country and in any other country. Why do we find elections very important? To the point that we have put all these very detailed provisions in the Constitution to protect the manner in which elections are administered. And therefore, that will reflect on the importance of the decision you have to make in this case. And I want to refer, my lords, to Article 4. The reason we go to periodic elections every 5 years is because we are a republic. Article 4 establishes Kenya as a sovereign republic. Sub-Article 1 says Kenya is a sovereign republic, and Sub-Article 2 says the Republic of Kenya shall be a multi-party democratic state founded upon the national values and principles of governance referred to in Article 10. And I want to point out that the problem in Africa has been that we make constitutions in which we put certain concepts, and we never seek to investigate, to understand the meaning of those concepts, so as to be able to see whether we are running our affairs consistently with the concepts we have put in our constitution. And so you end up with countries that call themselves republics, when in fact they are operating like monarchs or autocracies or dictatorships. And so the question we must answer here is, if Kenyans settled for a republican system of government as opposed to a monarchy or an autocracy or a dictatorship, what do they mean by a republic?
Sorry, Mr. Kangu.
Yes.
You know, your submission sounds like a lecture to first-year students in constitutional law.
Yes.
Could you please attack your case?
Fine, let me go to the point. My Lord, the point is that a republican system is the foundation of the sovereignty of the people. That if you are a republic, in a republic all authority emanates from the people, and that's why we have Article 1 in the Constitution. And elections become one of the processes through which the people delegate their sovereign power to representatives. And so the point I'm making is that if you attack the electoral system, if you mismanage electoral systems, then you are making a direct attack on the sovereignty of the people and on the republican nature of the state. So we need to protect the system of administering elections zealously if the sovereignty of the people is to be protected. Otherwise, these elections, the reality of it is that on the one hand, people may say it should not be easy for us to overturn an election because we'll be interfering with the will of the people. But on the other hand, it may be that elections have been mismanaged in such a manner that in fact the will of the people, the sovereignty of the people has been usurped. So there is need to balance that, to ask yourself, between protecting those you think have expressed their will in choosing a leader and those whose will may have been hijacked. Which one is the correct position given the evidence on the face of the record? And I want to submit, my lords, that from that point of view, that these elections were so badly conducted. Yes. Thank you. So I will be urging, therefore, that this case is about the protection of the sovereignty of the people of Kenya. If we can see there is a threat to usurp that sovereignty, we must protect it. And if you look at Article 249, you will be able to note that the Electoral Commission has a responsibility to protect the sovereignty of the people. One of the objects of commissions is to protect the sovereignty of the people. And you look through elections 2007, 2013, up to now, there seems to be a pattern where that state organ has failed in that responsibility. And having failed in that responsibility, I want to urge that this case before you is like the Kenyan people have come to you to defend the Constitution and protect their sovereignty. And if you look at Article 3 of the Constitution, it makes it very clear that every person has an obligation to defend the Constitution. The people of Kenya have come to you to assist them to defend the Constitution through lawful means and to protect their sovereignty. And so I want to emphasize that when you are making your decision, let that bear on your mind, that it is as serious as either choosing between to stand with the people trying to protect their sovereignty or to stand with those who are usurping the sovereignty of the people. Thank you very much.
Thank you. Thank you, Dr. Kangu.
Yeah. My Lord, we just have... My Lord, we just have two things to do. There's a matter of evidence that, through my learned friend, Mr. Otinda Molo, is going to lay a basis for it. It's something that may take less than 10 minutes. And I'll take 10 minutes thereafter to wrap up our case.
Very well.
Yeah. A bit of reorganization. Anthony Oloch will do it.
Your Lordship, Chief Justice, my ladies, I have just one small component of the evidence that was presented by my learned senior, Mr. Otiende Amolo. But before they play that video, I just wanted to draw Your Lordship's attention and your ladies to two paragraphs of two affidavits of the applicant, and then juxtapose it against the video evidence that is going to be played. The first affidavit is the affidavit of volume 2 of the first respondent, and it's the affidavit of James Muhati, and it goes into part of the evidence in terms of what kind of security features and compliance issues the first respondent put in place in order to ensure that there was a proper ICT infrastructure for purposes of the elections. It is important that we set out from the very onset that the IEBC set out a system which it has highlighted under paragraph 34 of the affidavit of Muhati. And at paragraph 34, and I will not read it, your lordships will find time to read it. It is a mirror of the video that we are about to present of the late Muhati, of what ought to have happened, the late Musando, thank you very much, if the electoral system, and especially the results transmission system, had worked in the manner contemplated. And so I would like your lordship to take into account paragraphs 34, paragraphs 35, and paragraphs 36 up to 39 of these affidavit. We also want to submit to your lordships that in terms of ICT security, we want to flag out paragraph 39 of the affidavit of Ezra Chiloba. That is the affidavit that was dated, sorry my lords, it's dated the 24th of August 2017. Looking at what Muhati says and the video that will be presented of Musando, the IBC set a system where it would have been impossible for third parties to have access or super access into that system. We set out in our evidence that in relation to a case that took place in Mandera, basically materials foreign to what is prescribed as Form 34 found itself into the web portal of IEBC. And in the affidavit of Ezra Chiloba, he admits that this was foreign material and not prescribed Form 34s, and says that he was able to get into the system and expunge this material. So then that puts into question the idea of the integrity of the infrastructure that was put in place by the IEBC. So those are the 2 points that I want to make, and there are 2 very short videos of the late Musando that we want to play. There are transcriptions of the same. We have also annexed the certificates to our applications. So please.
Mr. Oluoch, as regards this matter that you are now showing,
yes,
it is something that qualifies as dying declarations as evidence.
Pardon, my lord?
Does it qualify as dying declarations?
Not quite. Not quite. Not quite. I'm going to make a statement at the end that will clarify that point. So once we play it, I will make a point in relation to that. My lords, I'm reminded here by my senior that a dying declaration is made by somebody who says it in expectation of death. We don't think that the late Musando expected his unfortunate death, so it would not be a dying declaration.
I think in that case, we'll say something about the evidentiary strength. You'll have to say something about that.
Yeah. Okay, very well.
Summarize. No. If it doesn't come, yes, you'll refer the court.
Well, no, what they are putting in place in terms of resilience about technology and how we want to operate in relation to has taken into consideration very many aspects of possible failures. One of them is the total failure of the device. The other one is total failure of identification of the voters in election day, especially the biometric. But we have put measures in place to mitigate that. One of the measures that we have put in case of total failure of the device, we have standby devices. We have 40,000, that's about 40,800 polling stations. We have 45,000 devices, and therefore we have cut up for additional devices per award. Each ward will be having at least 4 devices on standby, fully configured and ready to be deployed in case of a full failure of a device. Besides that, we have also put in place the technical capacity of officers trained to be able to troubleshoot some of these devices in case of failure. Because you see, a failure can sometimes just be resolved by some technical knowledge, and that we have put in place. We are deploying 580 ICT assistants who will be well trained to support the technology on election day. And each constituency will have 2 technical people. We also have technical support at all the county headquarters, which has been provided by the Commission and also our technology partners who have provided additional cover for technology support on election day. That will give us a level of confidence that assures us that in case we are required to resolve issues of technology failure, we will be able to in good time. In our design for the resource transmission workflow, we have taken care of everybody in the chain, meaning everybody has a role according to the law. The presiding officer is bound by the law to send the results as realized in the polling station. The other thing is that they have to scan a copy of that result form and transmit it to the results. And that is in our resource management design. The returning officer have an access to the results transmission system. They can verify those results. They can validate those results within the system, but they cannot change those results, because that is what we are taking care of as a risk. Because we don't want the results as transmitted from the polling station, and the law says that final, and somebody else changing those results along the chain. So what they can do is to just validate the results as transmitted from the polling station. They cannot make any changes in those results. And neither can the national chairman, the national returning officer, make any changes to those results.
So the only point that I want to make is as I close, that it's important then to ask ourselves, from the affidavit of Muhati, who was Muhati? Muhati, prior to the death of Musando, was the former ICT director who was suspended or relieved from duty, allegedly for incompetence. The person that replaced him was Musando. And when Musando died, it is important to take judicial notice. The person who then replaces him again is Muhati. One last point then that comes out of this is that there was massive non-compliance if you compare the affidavit and what ought to have been done, as stated by Muhati in his own affidavit, and what is said by Musando. When you tie those two pieces of evidence with the evidence that was led by my senior Otiende Amolo, then we reach the inescapable conclusion, and we invite your lordship to find that there was two systems operating under IEBC. One that the public was made to believe had all the specifications and security features under the ICT regulations, and one that nobody knew about, that only IEBC can explain. It is under those circumstances that the fake or fraudulent Form 34s could have found themselves in the web portal and also found themselves before your lordships as evidence presented as Form 38s. So those are my submissions. Thank you.
There's one point that I raised. You haven't responded to it. We agreed that this is not a dying declaration. Therefore, you should say something about its evidentiary strength.
Yes. Thank you, my lord. I think this came against the background of very serious integrity questions or confidence questions that are being asked by the people of Kenya about the preparedness. And your lordship and my ladies will find that there are materials that were placed in our petition where the petitioner's political party or alliance raised several questions about the preparedness of the commission, questions about procurement, and questions about the KIMS kits that were going to be used. I believe it is against this background that it became necessary for IEBC to come out and impute or give that confidence to the people that we've put in place a system that will work. Unfortunately, that system did not work as Musando had contemplated.
Yes, my lords, with your permission, I just want to wrap up the submissions that were made so far and conclude this component of the proceedings of the court. And I hope not to take more than 20 minutes, at least save some time. My lords, we have to decide whether the provisions of the Constitution, particularly the provisions that relate to supremacy of the Constitution, are binding on all state organs and all persons, or they are provisions that can be overlooked. My lords, if you look at Article 2, sub-Article 4, it says any law, including customary law, that is consistent with this Constitution is void to the extent of the inconsistency, and any act or omission, this is where I want to put the emphasis, any act or omission in contravention of this Constitution is invalid. My lord, this is a provision that this court cannot overlook. And when we interpret the Constitution, and the tools of interpretation are given in, I believe, Article 259. And in that Article 259, you find, your lordships, that one of the interpretative tools says that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles. So I want to pose the following question, your lordships. And when you retire, probably you'll consider it amongst many other matters that have been placed before you. Men and women of faith, particularly Christian faith, to which I belong, and I'm an Anglican, in religious or heavenly matters, there's either heaven or hell. In some religions, there's a place called the purgatory, that you can rest for a while, depending on circumstances, go either side. But I think your lordships in matters constitutional, and using the tools of interpretation to make a decision whether actions or state organ are valid in accordance with the Constitution, or whether they are not valid. And we are a constitutional democracy, and these questions are critical. Therefore, in looking at this petition as a whole, when you crystallize the issues that some of the issues that you may have to look at. One of your questions, my ladies will want to consider. Did the winning candidate 30% plus one? Now, that question may be about circumstances where there was election held. But my lord, it is an election where evidence has been placed before you of systemic and widespread violation of the Constitution and the law. That question becomes moot, because if you look at the litany of violations that we need to, in consideration of this matter, particularly as you put before you by my friend Otiende Amolo. My ladies, you cannot ignore this factor, ungazetted polling. That is a matter you cannot ignore. And in looking whether or not ungazetted polling could be considered in trying to compute the numbers which were garnered by both candidates. That question does not lead this to come out with either the station was ungazetted or ungazetted. When you look even that question of rejected vote, my lord, account of your decision, and I don't want to revisit this matter. In respecting how this election was conducted, and the number of rejected votes, without having the possibility of whether rejected votes were as a consequence of the voter or the IEBC. My question of the answering whether or not those 500,000 votes should have been rejected or not rejected is very difficult in these circumstances, especially being held in this circumstance without the ballot boxes and the ballot papers being before your lordship. If my lord, consider the question of gazetted officers, returning officers, and presiding officers, what make out of their action or omission? That question cannot be answered in such a way that can help this court compute on a numerical basis who won, who lost, or who lost elections. And then, my lord, there was a question of the use of undefined statutory instruments is at the 4th and 4A and 34B. In fact, the evidence that nearly all those forms 34B as in document number, I think, 7. Nearly all of them did not bear all the features as required. These were coming from constituents. It makes it very difficult now for this court now to go and determine who got the most votes, or who more than 20%, more than half percent in more than half counties in the republic. And my lord, then the constitutional role of the IBC, not only in the general sections of the Constitution, but also what my other friend, Professor Kangi referred to, responsibility and burden. That is a fair in accordance with the Constitution. And the IBC placed in such circumstances where we are the ones expected to prove that they did not abide by the law of the Constitution. In circumstances where the evidence is placed before you and make an evaluation whether or not they are conducted in accordance with the Constitution. And finally, I want to say without fear of contradiction that looking from this as a whole, Form 34 and 34B, the irregularities are not just mere considerations. They spread across a panoply of omissions and commissions, which include forgeries, deception, and alteration of statutory documents, which are important for purposes of recording and declaring the results of the election. My ladies, I would invite the court that first principle is to apply the Constitution before you look at other translations. I think the first is to look at the Constitution, Article 81, 86, Article 2, and Article. Finally, in conclusion, I want to say this, my lord. You may walk into a bank and find a robbery going on. You may thereafter be able to report to a neighbor such a robbery. There was a robbery. You may go to another place that looks very peaceful, but there's a fraud of these elections. But you have now before you what we can make out of this election in terms of the documentation that has been placed. And our submission is that forms and documents tell of the elections held in accordance with the Constitution and the applicable law, which is the Elections Act. My lord, in conclusion of just being reminded, the video that just played, Mr. Musando was in his capacity as a public official, was giving a message to the country, and thereby generating a legitimate expectation of the people that the elections will be conducted in a certain lordships. We believe we have placed before you sufficient sufficient evidence to avoid this election to grant the prayer in its contained petition costs. We thank you, and I want to express our appreciation of the patience we've had since making this presentation.
keeping to your time. We have an interested party supporting the for the interested party exists. I would request IBC Council to also take their